Thank you.
Mr. Neguse.
Mr. Attorney General, thank you for being here. I also want to thank my colleague, the distinguished gentleman from South Dakota, on the other side of the aisle, for his support of criminal justice reform, and looking forward to working with him.
North Dakota.
North Dakota, my apologies. I look forward to working with him on criminal justice reform. I want to talk about another policy matter with respect to cannabis. I represent the state of Colorado. In Colorado, recreational use of marijuana was legalized in 2014. Today, more than half the states have legalized either the recreational or medical use of marijuana. Researchers at the University of Colorado, which I'm proud to represent, are working hard to understand the health effects. They're studying promising approaches that use marijuana to relieve chronic pain and the symptoms of Parkinson's disease. In August of 2016, I understand this is before you were at the Department of Justice, Mr. Attorney General, the DEA took a big step towards improving scientific research on marijuana when it submitted a request in the Federal Register for applications to produce federally approved research-grade marijuana. Several institutions have submitted an application that have yet to receive a response. What is the status of those applications, if you might know, and do you know if the Department of Justice and the DEA intend to support legitimate cannabis research that can help protect the health and safety of our citizens?
For the 3 months that I've been the acting attorney general, this is an issue that I've been aware of, and I've actually tried to get the expansion and the applications out. We have run into a very complicated matter regarding a treaty that we're trying to work around. We have some international treaty obligations that may not allow the way that marijuana has to be handled from the research facilities to the researchers, or the grow facility to the researchers. And so it is something that I am very aware of. It's something I'm trying to push. Unfortunately, I have 6 days left in this chair at the most. I don't know if I'm going to successfully get to it, but I understand the concern and know that we're trying to make it work.
I appreciate that and applaud that. And if I could get your assurances that within the 6 days, if you could just follow up with the department staff to follow up with our office in writing, it'd be incredibly helpful for us as folks reach out. So.
Yeah, we'll try to get an answer as to the current status, but in my recollection of where I last found it is that the
sure, no, that's sufficient. I want to make sure I get. Thank you, Mr. Attorney General. You mentioned earlier that the public essentially learned that Attorney General Sessions was fired on November 7th, 2018 by tweet, and you were appointed via that same tweet. When did you first learn that Mr. Sessions was fired or would be fired?
I learned on November 7th, if that's your question. I mean,
It is.
Yeah, okay.
Okay,
Yeah,
so you learned by virtue of that same tweet that we all learned?
I would suggest the only point I'd put on that, Congressman, I'm sorry to interrupt, but is that Mr. Sessions resigned, sent in his resignation letter.
Understand. So did you have any conversations with folks at the White House prior to November 7th, 2018 about Attorney General Sessions resigning or being fired, however you would characterize that?
As is the longstanding practice of the Department of Justice and the executive branch generally, the President's entitled to confidential communications, and while I'm not confirming or denying the existence of any conversation, I'm not going to talk about my private conversations with the President of the United States.
We will follow up on that front with respect, or would ask the chairman to take that up in a deposition to the extent that one is noticed. Question around, you mentioned earlier in some of your testimony around the reasoning behind your appointment, that one of the reasons you believed in your view that you were appointed was to the position of acting attorney general was your experience as a former U.S. attorney, correct?
Yeah, correct. I spent 5.5 years as the United States Attorney for the Southern District of Iowa.
Yes, sir. And you also mentioned that one of the reasons in your view that you believed you were appointed acting attorney general was that you've been at the Department of Justice for the last year or so, working as the chief of staff to Attorney General Sessions, side by side, I think you mentioned.
Yes, and I knew all of the active matters that we weren't recused from, obviously. I knew all the policies that we had not only implemented, but that were in progress. I knew all the people and the individuals, both inside the Department of Justice and the interagency.
Understand. I just want to reclaim my time here. So I appreciate that, and I guess the question I have is, I'm sure you're aware that Deputy Attorney General Rod Rosenstein is a former U.S. attorney, that he also has been at the Department of Justice, that he knows the people, he knows the matters, and that under the Vacancy Act, he was next in line in succession to be appointed Attorney General in the occasion at which that office was vacant, occasioned by Mr. Sessions' termination or resignation or what have you. And so I'm trying to understand why. I mean, were you surprised that you were appointed rather than Deputy Attorney General Rosenstein, that the ordinary rules of succession weren't followed?
It's been an honor of a lifetime to serve as the acting Attorney General, and I have, as I mentioned, 6 days left, and I'm going to take full advantage of that, including enjoying this hearing. But there are two different statutes that applied to the vacancy that was created by General Sessions' letter of resignation. And one was the succession statute by the Department of Justice, and as you know, the other one is the Vacancy Reform Act, which has been passed by Congress. And so my appointment, as is outlined in the 20-page OLC opinion, is legitimate and has precedent.
And I'm not, with respect, Attorney General, I was not referencing the legitimacy of the appointment. What I was saying is under the Vacancies Act, 28 U.S.C. 508, the Deputy Attorney General is the first assistant to the Attorney General, and so therefore would be the appropriate designee to fill that role. But with that, I yield back the time.
Gentleman is yielded back.
Chairman?
McBath.
Mr. Chairman, I'm sorry.
Yes.
I just wanted to address that issue really quickly, just so we're all on the same page. The first assistant, together with any other Senate-confirmed individual, together with anyone that's served 90 days or less, 365 days at a senior position, is eligible to be, and there's no ranking or hierarchy of those three positions. Obviously, I'm in the third bucket as Chief of Staff. I just want to make sure we're clear on that.